Thank you, good gentlemen. Is there further debate? Lady from 18.
Thank you, Mr. Speaker. To debate against the bill.
You have the floor.
Thank you, Mr. Speaker. So much has been said already that I'm going to try to stick to what hasn't been said so far, which is actually a fair bit. There are a lot of problems with this bill, and I don't know that we've even scratched the surface here. I think it's been pretty clear that, we certainly don't have a problem with overuse of initiatives in Idaho. I think we're pretty close to the bottom of the nation in initiatives passed. We've passed about one every 6 years since the power became available. So there was certainly hardly an epidemic of citizen action that needs to be reined in here. If there is a problem, actually, we are already at the outer bounds of what is possible in Idaho. I think we should understand that and make that clear. When you take everything into account, we're not the second. We actually probably are already the hardest in the nation of any state that allows these. We may be outside the outer bounds of what is really constitutional right now. And you may say, well, how can that be? We just passed one. There were two that just made it on the ballot. We just passed one. I think the standard is that it has to be reasonably feasible with diligence to get on the ballot. It has to be reasonably workable. Proposition 2 was not an ordinary process. This was off the charts, like a level the state has never seen. And I worked somewhat on it. There are many who have worked much more than I. This came out of 7 years of legislative inaction, creating a pressure cooker, the likes of which we probably haven't seen, a level of awareness in the population, a level of rage and frustration that was very atypical. So that created a process where there was an off-the-charts level of volunteerism. Thousands and thousands of people from every corner of the state participated in this to a level that had not been seen before and may never be seen again, frankly. If you listen in committee, people that you talk to, people were out with broken legs on crutches collecting signatures. People with cancer going through chemotherapy were out collecting signatures. The old, the young, the infirm, everybody was out there collecting signatures, nights, weekends, standing all day in farmers markets, going everywhere. This was an off-the-charts level of engagement. And I don't know that you actually should need that kind of level of engagement to make it on the ballot. You shouldn't need to be, Lance Armstrong on steroids to need to make it on the ballot. It should probably be a more reasonably attainable standard. But this is what it took, and they barely got there. It was pedal to the metal to the end. By the weekend before, they still weren't there. And they barely got there in the end. Under the proposal here, they would not have made it to a third of the requirements. The most epic, historic volunteer undertaking in the history of the state would have certified 10 districts under this standard. Nowhere near the 32, nowhere near even the 24 that's being proposed in the trailer. So careful what you ask for, because if you pass this, it's going to go to court, for sure. And I slept like a baby last night because I don't think I'm very comfortable that this will not find its way into law, just to say. I think no court would uphold this. But there's a really good chance that the existing standards get struck down as being too unconstitutionally severe. So be careful here. Now, let's look at what it would look like in court, because it will end up in court if it passes and if it's signed by the gentleman on the second floor. The proponents would have to show evidence that an initiative sponsor could reasonably meet the requirements. And so they're going to go through a lot of evidence and see where you get there. And of course, the fact that the biggest grassroots effort in the history of the state would not have come close to satisfying this is going to be a pretty compelling piece of evidence. And everybody that actually played a role in making that happen will be submitting declarations saying there is absolutely no imaginable way that this standard could be met by a citizen-driven initiative. So that's going to be one piece of evidence that I think is going to be pretty compelling. Someone may bring in evidence that this could be done with money, and that's true. I think with probably $3 to $4 million, you could hire enough paid signature gatherers to get there. But I don't think that saves this. I think it makes it worse. I think this is a right that's in the Constitution, which means it has to be real. It has to be genuinely available to people who are not multimillionaires. Article 3, Section 1 of our Constitution says the people reserve to themselves the power to propose laws. It does not say the people to reserve to the Koch brothers or to George Soros or to any other multimillionaire the power to propose laws. The people reserve to themselves. And under either 1159 or the trailer bill, that power is stripped entirely from the people. There is no possibility, it's not just a little bit harder, there's no possibility, I think realistically, that the people of Idaho in a citizen-driven ballot initiative could get on the ballot. Now, I'm sure some of you maybe are thinking, oh, well, I saw that Attorney General opinion that went around, and they say we're okay, so I'm not too worried about this. If the Attorney General says it's okay, well, Attorney General had a big caveat in there saying this may not be okay. There may be evidence brought that says that this is not reasonably feasible. And I think there's some critical flaws in that Attorney General's opinion. The Attorney General's opinion says, well, 10%, 10% was in Utah, 10% is what the law said in 1933, so 10% will be okay. 10% of what? That's like saying, I can eat 50% of a chicken, so I'm sure I can eat 50% of a cow. It's 10% of a very different number. And so I'd like you to pull out the chart that I've included in the materials that I circulated to you all. It's a chart. It has, 7, 8 columns. And this illustrates the extent to which we're comparing apples to watermelons when we say 10% of votes cast versus 10% of registered votes. Every state that goes by anything close to the 10% number is 10% of votes cast, not 10% of registered votes. Very different number, and this breaks it down district by district how different that number is. For example, in District 1, 10% of registered voters is nearly 3,000. 10% of votes cast is about 2,000. And if you look at the bottom, you see statewide, when you look at votes cast versus registered votes, what you're really looking at is you're calling for 15.2% of votes cast. That's a very different proposition. And you look at the numbers there, and it said the difference basically is 10% of registered voters requires nearly 91,763, and 10% of those who voted is 61,255. The 61,255 is if you applied our 1933 law or the Utah law or any of the states that say 10% of votes cast. So really what the Attorney General has said here is, well, since 61,000 is probably okay, then 91,000 is probably fine. That's a big leap. That's a big leap. I don't see a court going there. But it's actually way worse than that, because one thing that nobody's talked about is how uniquely onerous Idaho's signature verification process is. Unlike most states, in Idaho, when you submit your list of signatures, the clerk looks at every single one and compares it to your signature that's on record in your voter file. And if your name is Michael in the voter record and you signed it Mike on your ballot form, there's a very good chance that signature gets thrown out. And so, in fact, in Idaho, only 65% of the signatures submitted actually end up getting verified. So you really have to collect 150% of what you'll ultimately need in order to end up with the signatures you really need by the time it's made it through that verification process. Other states don't do this. Overwhelmingly, what other states do is they are presumed valid unless specifically challenged. So you're going to get more like a 95% plus affirmation rate of the signatures you gather. In California, for example, they only do a verification process if you submit a number of signatures that's between 95 and 110% of the signatures that you need. So if you overshoot it, they don't even look at them at all. Some of them do some random spot checking of the signatures. We look at every one and put it through the mill. So we're already walking around with a ball and chain around our foot in terms of our certification process. So when you apply that to this chart, and I probably should have written this on, what you really have to collect in order to end up with that 91,763 to make it through our uniquely onerous verification process, you really have to collect 141,174. So when you hear, well, we'd probably be okay requiring 61,000, well, as a practical matter, that means 141,174. That's a really big stretch. So when the Attorney General or Utah or other states say 61,000 is probably okay, so 141,000 would be okay, that's a very, very big stretch, and it really is hard to believe that a court would go there. That is onerous beyond belief. Onerous beyond belief. And so as a practical matter, that is what you would have to collect. You would have to go door to door and stand in farmers markets until you got 141,000 signatures, which is actually, just if we're getting into the math, that's actually 23% of the ballots cast in the state. Off the charts. No comparison to any other state in the union. This has never been done anywhere. It's never been done in Idaho, never in any other states. This is an order of magnitude off of anything that has happened anywhere else. And by the way, there is federal law in point that says severe restrictions on ballot initiatives do trigger strict scrutiny. This is unquestionably a severe restriction, and strict scrutiny is a very high standard to meet. It's really, really hard to see this satisfying strict scrutiny. This could go down in both federal and state court. But in any event, it's going to be a very costly battle, and it's certainly something that should have been factored into the fiscal note. Now, one of the things that's been pointed out, and I listened to all the committee testimony, is people were saying, well, you know, this one state does this part of it, and this other state does that part of it, and here's a state that has a shorter period, and here's a state that has a broad district requirement. But one thing that has been mentioned is these layer on each other, and they make it exponentially harder when you layer them on each other. It becomes much harder to get a higher percentage in a more rural area where they're farther apart in a shorter period of time. And I've been listening here to my friend from District 19 for a long time with his mountain climbing analogies. So, you know, I'm going to give a stab at one here. This is basically like requiring somebody to climb a 10,000-foot mountain with a 100-pound pack on and with a broken ankle. And by the way, because of Idaho's uniquely difficult certification mechanism, we also have asthma. So now, you know, no offense meant to my colleagues, but I have yet to meet a proponent of this bill that has actually been very actively engaged in collecting signatures for a ballot initiative. So I have. It's really hard. You go out hours and hours and hours, and you come back with like 10 signatures. It's very hard. But we seem to have a lot of armchair athletes here saying, you know, well, you know, I know this one guy that climbed a 12,000-foot mountain once, so I'm sure this won't be a problem. Like, well, did they do it with a broken ankle and a 100-pound pack? Nobody has. Nobody has. And you're not going to find somebody with real experience in this area who's ever going to tell you this is feasible. So, you know, this is, maybe you're not concerned about that, but if you don't want to see a costly legal battle, you know, please don't embark further down this path, because that is where it's going. There is no evidence. Nobody will be able to produce credible evidence from inside Idaho or from any other state to say that this meets the standard of being reasonably workable. So that's the legal analysis. That's legal. I'm a lawyer. I love that stuff. And, you know, there's that. But beyond that, is it advisable? And I think there's an even stronger case to be made there for that it is not. For one thing, it's very unpopular. And ironically, I think, you know, when you look in your package, you will also see a collage of all the headlines of just about every paper in the state writing op-eds saying this is a disaster, please don't do this, this is a naked assault on people's constitutional rights. I think there have been well over 7,000 signatures collected already, asking the gentleman on the second floor to veto this. The testimony in committee was overwhelmingly opposed. A letter from 4 former attorneys general, former secretary of state. This is, you know, saying that this is an unconstitutional power grab. There's pretty overwhelming public opposition, so I hope you'll take that into account. But I want to get into some of the things that may be driving this. I mean, maybe there's a fear of certain policies. Maybe there's a fear that we don't want marijuana to be legalized, or we don't want minimum wage to go up, or whatever. And yeah, there probably will be policies you don't agree with. And that is to be expected, because of course there will be. That's the whole point of this thing. They wouldn't bother doing this. Nobody's going to go spend thousands of hours knocking on strangers' doors if they think their legislature is going to help them. Obviously, the things they're going to push are the things that the legislature aren't going to do for them. So yes, that is built into this. That is structurally part of this constitutional right, is we should expect that they'll bring things that this legislature won't do. But that's just the way the cookie crumbles. That's what's in our Constitution. That's why it's there, and we have to live with that. And if you don't like that, then you probably shouldn't have sworn an oath to uphold the Constitution. It's what we have to do, and our Constitution is not a buffet. You can't pick which parts you want. This is in there, and it must be respected. I've heard some people say, including the gentleman from 22 just now, that we're not a direct democracy, we are a constitutional republic. Well, I wouldn't worry too much in that this body passes about 400 bills a year, and the people of Idaho have passed 15 in its entire history, about one every 6 years. So I don't think we're in great danger of direct democracy swamping our republic. But we are what our Constitution says we are, and our Constitution says we're a mix. Our Constitution says we are part direct democracy because of this provision. Our Constitution is built, unlike the federal Constitution, it is built where the people are implicitly a fourth branch of government that has the power to pipe up, and they are a check and balance. And trying to do this through legislation is like trying to legislate out the Senate, or trying to legislate out a gubernatorial veto or judicial review. It's totally inappropriate for us to be trying to legislate out a check and balance on our power that's built into the Constitution. this is a power grab, and it's an unconstitutional one, and if you don't like our Constitution, you should be working to amend it. This is something that I think would have to be done through constitutional amendment. It, for all of intents and purposes, totally strips a core constitutional provision, and that cannot be done through statute. That should be done and would have to be done through constitutional amendment. And if you want to put it on the ballot and let a constitutional amendment be voted on, knock yourself out. We'll see how much the voters like that. See how enthusiastic the voters are about taking away their own right to ballot initiatives. One of the things I've heard a lot is, oh, we need more places having input. We need the rural counties having, the rural districts having input. They have input. They vote. They voted overwhelmingly. If you look at, I see the maps on where the signatures were certified. If you looked at a map of where Proposition 2 passed, almost the whole map would be yellow because everybody voted for it. And rural areas voted in droves for this. People north, south, east, west, rural, urban, they voted in droves. And in fact, it helped the rural people most of all because they were on the brink of losing their rural hospitals. And how would rural voters have been better served if this had never made it on the ballot and they lost all their hospitals and they never had a chance to vote on something they passionately supported? It's not doing rural voters a service to pass a standard that is completely unmeetable and make sure there's never a citizen ballot initiative on their ballot again. Also, the notion that, we heard equal footing, and I agree with that. I think it should generally be on equal footing. We don't pass laws in this body requiring support of 32 districts. I wish 4 districts had veto power in this body. Because let me tell you, this bill certainly didn't have the support or input of representatives from at least 7 districts. But that's not how we do it. Here in this body, you can pass a bill with the support of legislators from 18 districts, which is what the law is right now, that you get signatures from voters in 18 districts. Why should there be this supermajority requirement for voters that is not imposed on ourselves? And ultimately, I agree 100% for once, and put this down in the records, I agree with the lady from 1. She put it so well, so well. We are asking the wrong question here. If we don't like citizen ballot initiatives, we shouldn't be asking how can we shut it down. We should be asking why are we making them necessary? Why are we putting our citizens through hell to do this? They should not have to spend thousands and thousands of hours on nights and weekends knocking on strangers' doors and standing around farmers markets to get the most basic policy issues discussed. It is our lack of responsiveness that drove them to that, and we should be doing the soul searching and asking how can we be more responsive so that we don't drive them to do this. This is the emergency glass that the citizens have to break when they feel we are not being responsive. The answer should not be that we wall over the emergency glass. The answer should be that we are more responsive so that we don't force them to break it. So for all of these reasons, I ask very much that you avoid costly litigation, that you leave voters' rights intact, and that you vote no on 1159.
Thank you for that debate. Is there further debate?